In this Smythe versus Pillsbury case, this was a suit because the defendant intercepted employees' emails that he had saved in his personal email on or personal file on his work computer. In this particular case, the court again struggled with the fact that the employer had made continual assurances to the employees that all emails would be confidential and that they would not be intercepted. This particular case involves intranet. Many of you and your employers probably have intranet systems where you can communicate with anyone that's employed without using the internet. So it's somewhat more restrictive. Well, this was an intranet system, and this particular employee, because he had been assured that none of his emails would be intercepted and that they were confidential, sent some inappropriate, or responded actually with some inappropriate emails to his supervisor. He argued that it was an invasion of privacy to actually intercept those emails and record them, and he argued that he had a reasonable expectation because of the assurances that had been provided by the employer. Luckily for the employer, the court found otherwise and found that there was a legitimate business interest in preventing inappropriate, unprofessional comments or illegal activities in this particular case. But what you need to take from this case is that even if you are monitoring, you need to make sure that your employees know that and that they do not think that you're not monitoring, or because of your failure to monitor consistently, they feel that even though there's a policy out there, you're not going to actually enforce it. That could actually create a reasonable expectation of privacy in certain aspects of their work that you are not anticipating. In the Leventhal versus Napa case is another example of where the court found that employee had an expectation of privacy. In this particular case, the state agency that the employee worked for did not have a general practice of routinely conducting searches of office computers, or had placed the plaintiff on notice that he should have no expectation of privacy. This again goes right back to your human resource policies and procedures and how you train employees or what you tell them. In this case, there was a search of a workplace computer where the employee had some expectation of privacy because he had downloaded information into private files that were not on the quote-unquote employer system. The employer argued that they needed to investigate an employee's misconduct because of an anonymous call that he was not performing his job. What they did was they went on to they searched his computer database from a remote database and found all the files that he had. They did not go in and read the content of the files, but the files were labeled, and one of the files was a personal tax preparation program that he had been using while employed with the state, and he was terminated for that reason. The court found that that was a legitimate business reason, but if they had gone into the content of those files again, they would have been in a more difficult position. So this case is another very good example of an invasion of privacy case. In this case, the key, again, was a reasonable expectation of privacy. This particular employee argued that he had been lulled into a false sense of security and privacy in the use of his computer because of the lack of enforcement. In this case, the employer accessed files that the employee had stored in his personal folder. This is all sounding familiar. People are trying to get around the argument that they have no reasonable expectation of privacy by putting things in personal files that are clearly labeled personal file of employee. But he had stored these files on the U.S. Bancorp's computer network after accessing them through his personal email account. Now, there are several employees who believe that if they are on their lunch hour or even during work, if they go on to a private Yahoo Mail account, enter their passcode, and get onto their private email, that that is not searchable, nor is it workplace property. They are wrong. If you go on if you are at work and you're on your work's computer, first of all, those things are completely trackable. So once you go into the workplace computer, even if you're going onto your own private account, that is stuff that the employer can obtain access to. And you do not have a reasonable expectation of privacy in it as long as your policy says so, and as long as that's enforced. The employer also remotely, the employer actually accessed those personal folders and also remotely determined the addresses of websites he had visited while at work. The court found that most employees have a higher expectation of privacy when accessing personal internet email accounts, such as Netscape or Hotmail accounts, even when doing so at work. However, it's an entirely different issue whether the expectation is reasonable when there is an explicit computer policy. So in this case, the court focused exclusively on the policy that was in place by the employer. The court found that the defendants only accessed the record of the addresses of the web pages that plaintiff had visited, and that situation was wholly unlike a more invasive search involved where the actual content of the websites was reviewed. Again, the courts are pitting when you have an actual label or just the addresses visited or the subject matter of emails as opposed to actually going in and reading the content of those emails. Given the great variety of work environments, the question whether an employee has a reasonable expectation of privacy is addressed on a case-by-case basis, which makes your jobs so much more difficult because you have to make sure that you are instructing your employees correctly and consistently. Now, this is a very interesting case, this next one. In this case, servers at a Houston's restaurant launched a password-protected MySpace group where they vented about work. The MySpace page ended up containing sexual remarks about the employer's management and its customers. It also had jokes about the employer's standards for customer service and quality and references to violence and illegal drug use. You can see how an employer, in this case the restaurant, would have an interest in knowing that stuff, especially if they are being defamed online or there are health issues arising out of these types of statements. In this particular case, after the managers knowingly accessed the employee's MySpace page without authorization, the employees were terminated. Those employees then responded by filing a privacy lawsuit against the company. The employees argued that it was a restricted access MySpace page that you could only get on with password protection, and that they had an expectation of privacy in that web space. In this particular case, the employer filed for summary judgment, and it was not granted because of an invasion of privacy issue. The court found that the employees expected only invited users could see those postings, and there was a disputed issue as to whether the employer was voluntarily allowed access to the website. In this particular case, the dispute was whether another employee who saw the MySpace page gave the manager access, or if he gained access by saying he was somebody who he was not. Whether an employee gave the employer consent to view postings was disputed in this particular case, and the jury had to decide the reasonableness of it. And the main thing that you want to take out of this particular case is that you need to notify your employees that anything they do, even on their personal computers, may be monitored and reviewed and may be the basis of termination if it is something that detrimentally affects the employer and, of course, is not some kind of protected activity.